Welcome back, or welcome to those of you who are just joining us for this segment of our virtual conference on crisis lawyering. For those of you who were with us before, I hope you will agree we are off to a terrific start with our two principal conveners, Ray and Eric, who brought us together around this important project, talking a little bit about the framework of their important book, and then an amazing panel of senior leaders talking about their own experience with crisis management and crisis lawyering in particular. We're now going to turn our attention to our next panel, and I am just absolutely thrilled to have my colleague and friend, and I have to admit with pride, former student Scott Westfall, who I will ask to turn on his video and his mic, who will moderate the next panel about how we can teach lawyers in various settings about these critical skills. Scott, thank you very much. The floor is yours.
Thank you, David. It's a pleasure to be with everyone here, and humbling to be part of this conversation with just an incredible range of perspectives and experts here with us. So the critical question that we're going to explore is, does traditional legal education and training in law school through common career paths across the arc of lawyers' careers prepare lawyers well for the rigors of lawyering in crisis situations? The world's becoming more complex, and this is a big question for legal education, both at law schools, but within legal organizations as well, because training needs to occur and across the arc of someone's career. As Tom said earlier, leadership development is really critical in a continuing way across lawyers' careers. We have the perfect combination here for our panel. We have a brilliant clinical legal professor from a very important clinic at Yale Law School, a public sector expert in crisis response who has led a major effort to train lawyers in crisis response in the field, and a general counsel at one of the world's most important companies whose daily life is managing crises. With that, I'm going to ask our panelists, Muneer, Ahmad, Brad Kieserman, and Lisa Tanzi, to turn their cameras on, and I'm going to introduce you one by one, and then we'll get to some good questions here. So first, Muneer Ahmad is the Deputy Dean for Experiential Education and the Saul Goldman Clinical Professor of Law at Yale Law School. He co-teaches in the Worker and Immigration Rights Clinic at Yale, and he and his students represent individuals, groups, organizations in both litigation and non-litigation matters related to immigration rights, and labor, and all the intersections among them. He's represented immigrants in a range of labor, immigration, and trafficking issues. For 3 years, he represented a prisoner at Guantanamo Bay, and he's written extensively on all these topics, and most recently a chapter in crisis lawyering with his colleague Michael Wishney, called the chapter is entitled "Calling Air Traffic Control: Confronting Crisis as Lawyers and Teachers." It's one of my favorite chapters in the book. I'll tell you why in a second. Our next panelist, Brad Kieserman, is the Vice President for Disaster Operations and Logistics at the American Red Cross. Since 2015, he's been in that role. He leads disaster readiness activities and oversees all of the American Red Cross's domestic disaster operations, including all U.S. territories and commonwealths. He and his team are responsible for staffing, logistics, operations, situational awareness, the planning, implementing, managing scalable relief operations to meet the direct needs of disaster clients and assist in their recovery. So it's a huge mandate that he has. Prior to the Red Cross, Brad served in the United States Coast Guard in enlisted, commissioned, and civilian positions. For 23 years, was a member of the Federal Senior Executive Service as well, holding legal and operational positions at both the Department of Homeland Security and at FEMA, where he served as chief counsel. We'll say more about that in a little bit. And during over 30 years of public service now, he has taken part in a lot of crisis operations, ranging from the Exxon Valdez oil spill, maritime mass migrations from Haiti and Cuba, international drug interdiction, the piracy of the US flagged vessel Maersk Alabama, great movie about that, and the response to and recovery from Hurricane Sandy. And finally, we have Lisa Tanzi, who is the Corporate Vice President and General Counsel for Customer Experience and Policy at Microsoft. We'll say more about how unusual that title is and why that title exists as Lisa offers her comments in a bit. She leads a team of approximately 360 people in legal, government, and community affairs, as well as digital crimes professionals located all over the world. She's also responsible for legal support for the Microsoft Commercial Sales Organization, having joined Microsoft in 1995. So back to our key question. We have a lot to talk about here. Does traditional legal education and training in law school through common career paths prepare lawyers well for the rigorous of lawyering in crisis situations? We're going to start with you, Muneer, to tell us about your experience as a clinical legal professor teaching at Yale Law School's Worker and Immigration Rights Clinic at the height of the Trump administration's immigration orders banning individuals from predominantly Muslim countries. Muneer, I have to say, we haven't met in person ever. Your chapter is brilliant. You unpack the typical approach to clinical legal education, and then you offer some really helpful observations about how law school clinics and clinical faculty can adapt their traditional pedagogical approach to be able to include student teams in crisis lawyering situations. In normal times when you're teaching your clinical students, there's very little time for if you do a plan, do, and reflect model is how you describe it in your chapter. That's not always possible in a crisis situation. And, we'd love for you to tell us about your experience running the clinic, during that extraordinary time. What was similar? What was different in your learning and teaching? What are the takeaways? And what leads you to conclude that crisis lawyering is regular lawyering? Thank you, Muneer, for being with us.
Thanks, Scott, and thanks to everyone for the opportunity to join this conversation. Maybe what I'll do is I'll start with a very quick description of the work that we did in around the first Muslim ban, and then come back to the questions that you've posed, Scott, about what this, how this either fit with or departed from the conventional approach of law clinics, and start to suggest some lessons for how we might think about legal education in relation to crisis lawyering and the role of legal education preparing crisis lawyers. So the story that I want to tell begins on January 27th of 2017. It was 1 week into the Trump administration. And my colleague and co-author, Mike Wishney, got a phone call a little after 10 o'clock that night from two of our former students, Becca Heller, who runs the International Refugee Assistance Project, and Justin Cox, who at the time was a litigator with the National Immigration Law Center. And there had been talk in the previous days that some form of Muslim ban was coming, but nobody knew exactly when, and no one knew what the contours of it would be. Becca and Justin called because they had clients who were arriving at JFK Airport that Friday night, and who were being told that they were not going to be allowed into the country, and in fact would be placed on planes and sent back, in this case to Iraq, by operation of this ban, which at that moment no one had actually seen. The two individuals involved, the first, his name was Hamid Khalid Darish. He had been an interpreter for the US military and had worked with US military in Iraq for over a decade. And he was coming on a special visa, which was only available to people who had worked closely with the US military as part of the operations in Iraq and Afghanistan, and had been through kind of extensive vetting in order to be able to obtain this visa. We later learned about a second man who also became our client, named Haider Samir Abdul Khalik, who similarly was coming on one of these special visas. But they were held up at the airport at JFK. So that phone call at 10 o'clock or so led to an email which my colleague Mike sent out to a group of our students and other colleagues saying, there are people stuck at JFK. Is anyone available to help put together a quick habeas petition? A habeas petition being a way, a filing in court to get someone released from the government's custody. That then led to probably a dozen students and lawyers from the two organizations who initially placed a call to Mike, as well as the ACLU Immigrants' Rights Project, all getting on the phone for a conference call at about 11 o'clock that evening. I'll fast forward to say that we went from 11 o'clock at night to about 5:30 the next morning, identifying claims, researching to the extent that we could, drafting, and actually filing a complaint for a class action, which got filed at about 5:30 the next morning. We spent the rest of that day engaged in more legal filings in order to set up a hearing, as well as in a range of different kinds of advocacy with community-based organizations, the media, a number of others, because people may recall that that Saturday, airports around the country were swarmed with protesters. And so there was an opportunity there for some intersection between what we were doing on the litigation side and the protests that were going on. This all culminated in a hearing in federal court, a kind of extraordinary hearing on a Saturday night in federal court. The courtroom was packed. The courthouse had a very large group of protesters outside, and a federal judge issued the first injunction nationwide that enjoined the Muslim ban less than 24 hours after it went into effect. So that's what, that was the work. It was roughly 24 hours of work, but it built in some ways upon a structure that we had in place in the clinic, which we didn't realize was set up to handle these kinds of crises, but in some ways was. We had built up over the course of our practice certain kinds of competencies. So for example, the idea that we could toss up a habeas petition was something that in the first instance seemed reasonable because our clinic has done dozens and dozens of habeas petitions in other contexts before, and our students knew how to do that. We institutionally knew how to do that. We had relationships that were essential to this work coming to us in the first place. The work came to us through former students. We were able to quickly engage a large number of organizations and lawyers, many of whom we had longstanding relationships with. So there was pre-existing trust and opportunities for collaboration and the ability to move very quickly, which reflected a kind of vision of our work as being embedded in communities rather than as just operating kind of solo. And we had cultivated a kind of culture of experimentation in the clinic. Many clinics traditionally have tended to take on relatively small matters on a fairly predictable schedule to deliver a uniform experience to each student who comes in. So the kind of paradigm example of a case that a clinic historically might take on is one that begins with a client interview, moves on to some research and some briefing, and ends with a student or students standing up in court and making oral argument. This obviously didn't track onto that schedule at all, but in some ways we had long deviated from that model and had invited into our clinic a kind of experimentation and an ability to try on different kinds of cases, to enter them in different stages and different phases, confident that there would be learning to do regardless of where and when we started. But always kind of coming back to, as you said, Scott, this general approach of plan, do, and reflect. And while the planning in the Muslim ban case was compressed, the doing was accelerated, and the reflection was somewhat delayed. In many ways, we hewed to that same model, even as we pushed each of those three poles in different directions.
Yeah, and one of the things I noticed too, Muneer, is that you had to vary somewhat the nature of what you're doing as clinical faculty then, in that you had to do more of the work than typically you might. You're typically in the background, the students are in the foreground doing the work, but by watching you and Mike and your other colleagues, operate, and the students, as apprentices, it sounded more like the regular kind of the traditional apprentice model, but there they were. Thoughts and reflections for other clinical faculty members about how they should think about this and that balance between what the students do and what you did?
Yeah, so there are historically these two hallmarks of clinical legal education. The first is for students to assume the role, to assume professional role, and to take on the responsibilities that come with being out in front, rather than being an apprentice or being an intern to a lawyer. And the second is critical reflection. And you're right that in this case and in other emergent situations, there have been, it's really been necessary for us to deviate from that paradigm. And at different stages, we as the experienced lawyers have stepped more into the role that traditionally students would occupy in a clinic. We have not done that lightly, and we are quite committed in our clinic here and really in all the clinics at Yale, as is the case at Harvard, and most schools across the country. We're quite committed to that principle of role assumption, because for students to step into professional role and to feel viscerally what it means to carry responsibility for a client, and to understand that they have ethical duties, ethical obligations that, you know, don't go away at 5 p.m. or don't go away at 11 p.m. when you go to sleep. That's actually quite essential to the pedagogy. That said, we have, through the experience with the Muslim ban litigation and other types of crisis lawyering that we've done, we've also recognized that there is pedagogical value, or there can be pedagogical value to some deviation from that. And we talk about this in terms of modeling. So for our students to see us as experienced lawyers moving into spaces that are also unfamiliar to us invites a kind of humility on our part as teachers. It reminds us of what it's like to, for our student, what we ask our students to do every day in the clinic. For us to do it periodically, I think is quite helpful. It deepens our sense of empathy for what the students are doing. It reminds us how difficult it is. But it also gives the students something to look at and to react to. I found that one of the most satisfying moments actually in my teaching has been when the table is flipped and I'm no longer mooting my students, but my students are mooting me. And we don't do it that often, but when we do, again, it's a different kind of learning experience for the students, and it enhances, I think, our ability as teachers going forward.
And as someone who teaches about leadership and teams and the courses for law students that I teach and in our executive education leadership programs, I think it's marvelous that they're getting that experience of a non-hierarchical team where everybody is contributing, everybody is moving together and solving the problem with people taking on different roles. It's something in my opinion, we don't do enough of in legal education, and we're not preparing people. This is a perfect segue to you, Lisa. You know, as we talked about on a recent call, you know, it'd be great if you could share your perspective about how crisis lawyering permeates throughout corporate practice, especially in the very, you know, challenging, uncertain times that we're living in at a very important global company like Microsoft. In your environment and in your role, you noted that things don't get to you unless they're really tough and challenging and probably already a crisis. Almost every day is an opportunity for crisis lawyering. You know, building upon Muneer's contribution here on this idea of modeling. You know, what are some of the techniques you've developed to help prepare your lawyers for this new environment, especially as they become more senior? And also, I'd love for you to tell us some about how the Microsoft legal department generally has been reorganizing in a really incredible way to meet the interdisciplinary challenges that this perpetual state of crisis, you know, seems to bring forward. And thank you so much for being with us, Lisa.
Thanks, Scott. And I'll just start by saying, you know, when I thought about crisis lawyering, I wasn't entirely sure the first place I would go was in-house lawyering. But as I started to sort of just think through the different things we deal with on a regular basis, I was like, yep, we've got our own sets of experiences here too. And so what I thought I'd do before I jumped into some specific examples is just reflect a little bit on the characteristics that I think are pretty consistent across all of the scenarios. And they echo a lot of what people have, you know, written about as well. I mean, it's, you know, an issue of significant impact and importance. It's usually a surprise. There's some kind of uncontrollable event, typically external, but I will also put a footnote on in the corporate environment, it can certainly be internal as well, and I'll spend a bit of time on that. And obviously, then we're trying to make key decisions with a limited amount of time and a limited amount of information. And so when you just think across, what are all the potential external types of events that can cause crisis lawyering? They're vast and they're very different, right? You can go from something like COVID, which has a super broad impact, to something that is very company specific. So when I think about COVID and when that first hit, you know, for us, we were dealing with everything from obviously employee safety issues to, oh my gosh, some countries around the world actually require physical signatures and not digital signatures, and how do we sign contracts and book revenue, to lockdown orders going in effect around the world, and how do we get our employees to data centers? And you know, what happens if they weren't identified as essential workers, but government officials aren't in their offices? And so how do we engage to make the case? And what do we do when employees are harassed on the streets because they're out in violation of a lockdown order, right? Like, that's one broad span. But then you could go to stuff that might be even sort of more sector specific. And you and I talked about this on the call the other day, where we do see a lot of countries around the world getting faster in their pace of regulation. So it passes more quickly, doesn't have the same kind of engagement with industry. And then even more importantly, timelines for new legislation to go into effect are very short, or they're getting shorter. And for us, when we think about, oh my gosh, well, now how do we get all of our products ready in such a short period of time? You know, that can cause some crisis thinking for us. Then I'll just shift and say, hey, you know, think about either company or even industry scenarios as well on something like cyber attacks or ransomware attacks. Or, you know, you have a dispute with a government and you're in the middle of a dawn raid, which means, you know, officials come in, they start taking papers, computers, start talking to employees. Or there might be other employee safety issues where people are called in for intense questioning, or they get visited at home, or they're wrongfully detained. So very vast set of external issues, but I also did want to pause a little bit on maybe the internal surprises, and because they happen, and you know, you'd think they might be more controllable, but they happen. And I'll just give two here. You know, we create different versions of our products sometimes for different regions based on regulatory requirements. And occasionally you might find yourself waking up to an email that says, oh, you know, we might have shipped the wrong thing into the wrong country. And then, you know, you're scrambling because you have a compliance issue that you have to clean up. Or, you know, you're at the end of a long negotiation and a deal, you've kind of gotten just ready to do the PR announcements, you put that in motion, and you go through the internal processes and you find out somebody missed a step and we actually don't have all the right approvals, right? They're not the same type of crises, obviously, as Muneer is talking about, but they do generate that same kind of, oh my gosh, I've got to solve for something pretty important in a short period of time. So then when I reflect on kind of what do we do to think about how do we prepare people, how do we better prepare ourselves collectively for any future crises, I sort of look at it by saying, hey, never let a crisis go to waste. And what I mean by that is, like, we have to learn from everyone we actually do, because we'll know we'll make some different mistakes, but gosh, I hope I don't make the same mistake twice. And so a super important piece of this for us is actually postmortems. And, you know, that's the crisis is over. We want to give people time before we do postmortems. I think that's super important for a couple reasons. One, a lot of times people have lack of sleep during crises, and you want to get people an ability to just kind of get rested. And also, I think distance helps with perspective. But then we get everybody on the team together. We kind of just, you know, do a couple of hours in a conference room or virtual teams now and just sort of say, hey, what went well? What did we miss? What would we have done differently? A lot of times this comes down to like role clarity, process clarity. And we write down our learnings, where we like playbooks, because playbooks at least give people a place to start the next time. Sharing out your learnings is important. Also, I would say trainings are important on some different disciplines that maybe lawyers don't typically get in law school, at least not when I was there. PR training is actually super important for us, because PR, messaging, how you engage with all of your stakeholders is usually a critical part of a crisis. They're core members of our team, but we want our lawyers to be sensitive to thinking through PR issues. Also program management skills, because a lot of times we find our lawyers are kind of the organizers. They're the ones sort of bringing the teams together, helping figure out who needs to be informed, what are the next tasks, how do we bring people together to report out. And then I would go to kind of what you were mentioning there, Scott, about our recent reorg. Sometimes you do make structural changes. And we did make some big structural changes back in July of this year. And the framing for that was, when we look ahead for the technology industry, we think we're going to see a lot more regulation on all fronts in the coming years. And we need to be ready for that. We can't be reactive. And so a core part of our reorg was getting clear on roles and responsibilities for how each entity was going to participate in that. And then thinking through how we pull together our multiple disciplines, both within CELA and outside. Like for us, engineering help is obviously super important. But how do we bring those together so that we really do approach this from a multidisciplinary perspective?
Which is, highly unusual in the legal, world and structure. And so we're following this really closely, hope to write a case about you all someday that we could be teaching about. Picking up on one of the things that you talked about in particular, this idea of the post-mortem. One of the things that, I contributed a chapter in the book and talk about is the fact that we haven't, and it's mentioned before, we haven't trained lawyers how to work in teams. The experts would say that lawyers typically work in a hierarchical, loose working group, where there's someone at the top and things trickle down and stuff is kind of assembled back up, but there's not a team launch meeting. There's not regular reflection about what's going well, what's not, and there's very rarely a post-mortem. How did you decide and get, how have you been able to get lawyers to do that? Because they're always moving to the next thing, right?
Yeah. For us, it's definitely cultural. I mean, it's been around for a while, but if I sort of think back to when we started, because at some point it was new for us, right? And I would say there were probably some places where we felt just things didn't go super well, right? And, Brad, our general counsel at that point, was pushing us to say, look, we need to do something different. We need to have sort of a learning culture. And for us, that's also an important part of the Microsoft culture now, where Satya sort of talks about, growth mindset and saying we're not know-it-alls, we're learn-it-alls, right? So it is this constant notion of learning and reflecting. But I'll also say feedback is an important part of the culture. And this, I will say, is, can sometimes be challenging for lawyers because, we're all trained to debate, right? And to push and pull on issues, and really talking about, the culture of feedback, because then you can kind of get into a post-mortem environment. And it's not about pointing out something that somebody did wrong. We all sort of go, hey, this isn't about any blame or wrong, signing wrong. It's about how do we get better as a team? And I think if you can create the culture where everybody is like this is not a harmful thing, this is a helpful thing to make us all better, that is just super important to have this, I think, work well. Because if people aren't honest going into that post-mortem because people are afraid, you don't get the real value out of the post-mortem.
Right, and these structures, can be incredibly important to create that learning and open culture, which is really important. I tell all my law students, Muneer, that they have to take a clinic before they leave Harvard Law School, because that's the one place where they're actually working in teams. Otherwise, you can go through 3 years of legal education never working in a team, which is something we have to fix, and we're trying. But building upon that theme, one of the most important post-mortem reflection efforts in, I think, U.S. crisis leadership history, something that, Brad, you actually led. You've been thinking about these issues for a very long time. When you were FEMA chief counsel in the aftermath of Hurricane Katrina, you led this effort to improve the performance of FEMA lawyers in crisis situation through a massive post-mortem. One of my favorite quotes that came out of that post-mortem from a FEMA emergency response officer in the field was, look, I don't need my lawyer to keep me out of court. I need my lawyer to keep me out of jail. and the post-mortem that you did and the context in which you and your colleagues addressed what were the gaps in the delivery of legal services in that crisis, and how could FEMA lawyers be trained and developed to do better the next time around. We'd love to hear your thoughts on that, and just more generally, what it means to be a salty lawyer, and I'll let you explain that.
Thank you very much. So it's a fascinating question. I think I'd begin with the premise of the first thing we had to deal with in the aftermath of Katrina. And I'm not talking about a week, a year. I was actually at the Coast Guard working for Admiral Allen at the time, who was ultimately became the chief federal coordinating officer. But a few years after Katrina struck, which was people were still reeling, I was at the Department of Homeland Security as an associate general counsel for ops and enforcement, and I got an opportunity to go over to FEMA. And when I got there, I wasn't well received. They weren't happy about having a chief counsel, or really any counsel at all. And the administrator had asked me to come, and I said, Craig, what do you want me to do here? And he said, you need to get the agency to use its lawyers, and you need to figure out how the lawyers are going to do that. And the first thing we did was a survey of all of the clients and all of the lawyers. And when we did that, I went personally to the clients and said, this is going to take you a couple minutes, but we really need you to do this, because otherwise we're going to keep getting the same thing we've got. And you're not happy. The lawyers aren't happy. We're going to try to do something here. And ultimately, what the clients came back with was, hey, lawyers, you're overrating your own effectiveness. And the reason we knew that is we asked the lawyers how they thought they were doing in certain areas. We asked the clients how they thought the lawyers were doing in certain areas. And then it became very clear where there was misalignment of values. And you use the term SALT. And so I'll cut to the chase on that. When we evaluated all of the survey results, what it came down to was the biggest gaps between the lawyers and the clients. Remember, FEMA is an emergency management agency. FEMA does two things. It writes checks and it has meetings. And generally, no one comes to the meeting unless FEMA's written a check. And so there's it's a grant-making organization. It's also an organization that coordinates when emergencies happen, but it lives in a time, it really does live in near constant crisis. And so the client said, we need lawyers who are solution oriented. You're not giving us solutions. You may be giving us advice, but you're not giving us solutions that are oriented towards the problems we have. When you do give us solutions, we need to understand what you're talking about, because sometimes when you talk to us, we don't even understand what you're saying. And there's a footnote to that. And many of the clients felt the reason the lawyers didn't understand how the clients needed to hear the advice, or the clients didn't understand the lawyers, is because the lawyers didn't understand the mission. They just didn't understand the mission of the organization. They understood the mission of the law firm, just not the organization it served. And then, so that got us to solution-oriented, articulate. The clients all agreed that they needed legally sufficient advice. I did have to have a conversation with the largest group of clients, these federal coordinating officers, and I said to them on your jail comment, look around. Have any of you ever been to prison before, right? Do you know any other FCOs who've gone to jail? Your risk isn't going to jail. So let's stop talking about you going to jail. We're not going to let you go to jail. And if you go to jail, it's because you probably did something dumb on your personal time. That's not the risk you're facing here. Let's talk about the real risks we're facing together, and not some abstract concept of that. And I think that was important to get the clients oriented. Their risks weren't jail, and that sort of bravura wasn't getting us anywhere. And so, last but not least, they said that they wanted advice that was solution oriented, articulate, legally sufficient, and timely. And if you look at those four characteristics, what it comes down to is lawyers do operate in a world of other people's continuing crises. Lawyers are used to giving advice during other people's crises. But you as a legal advisor can find that you're in crisis, even giving advice, hence the notion of advice in crisis, because you may not understand what the client's dealing with and how you can truly be helpful to the client. So I turned a couple points real quick to Lisa. Lisa did a absolutely brilliant definition of what a disaster is. And it was clearly very intuitive, but I'm going to cover some of the key parts because I think in terms of teaching lawyers to be ready for a 21st century practice, it's important to understand that there's emergencies, there's disasters, there's catastrophes, there's literature on all of these things, but it really comes down to this. Emergencies are when you've got a need and you have enough to meet it. Think about a two-car accident in most communities. Plenty of police, plenty of fire, plenty of ambulances. Is it a disaster, perhaps a catastrophe for the person behind the wheel? Maybe, but not for the community. There's enough resources. A disaster is when you don't have the resources that you need to respond. And what do you do then? You go ask for help. You ask the state for help. You ask the president for help. You ask for help. And there's legal structures by which those asks come. And then there's legal obligations that flow from making those asks and accepting the help, right? After Katrina, we had a very different problem. And this is part of what we had to learn to train people on, because there's a third category of crisis, and it's called a catastrophe. And a catastrophe is when the very incident you're responding to is destroying the very capability and capacity you need to respond. Practicing law in each of those very distinct areas, an emergency, a disaster, and catastrophe, is different. And it's different in each area. And I would argue that I'm a big fan of the Brandeis quote from the prior panel, which is, you are a lawyer for the situation. You just have to understand what that means. It doesn't change your ethical obligations as a lawyer, but it does require you to take a broader view of ethics, because your clients are dealing with, how do I make decisions? What's the ethical foundation on which I make a decision? Who am I helping? Who am I not helping? Because in any situation where there's insufficient resources, somebody's not going to get what they need. And that's what the clients are constantly dealing with. And today, I'm a client. I'm not a lawyer in practice today, my lawyers understand that I'm trying to meet unmet need, and I'm trying to do that in an ethical fashion. And I get great support and advice because it's solution-oriented, articulate, legally sufficient, and timely.
Yeah, I love that. Having your Coast Guard experience must have contributed to that acronym, I'm thinking, but salty legal advice is something we should all, take to heart and think about. And, in our, in traditional legal education, of course, one of the best things that we do is teach people very rigorous analytical thinking. Lawyers coming through a law school experience and then moving into private practice and public sector are prepared to take large amounts of data, find patterns, analyze from different angles. Then there becomes a critical juncture, and we've had a question from the audience that I was actually going to ask anyway, so thank you, audience member who contributed this, but there's a moment then when someone has to make a judgment, and in the situations in which each of you are functioning, especially during a crisis, the lawyer has to be someone who's making a judgment. They're just, David talks sometimes about the one-handed lawyer who, the client comes and they need the lawyer to make a judgment. And the lawyer says, well, on the one hand, and on the other hand, and you've got, how many hands does the lawyer have? And they're not helping to make a judgment. How can we teach judgment? I'll ask each of you. Brad, start us off since you're warmed up on this topic right now.
Well, I think first of all is recognition that lawyer risk tolerance and client risk tolerance may not be the same, and in crisis, I'll almost guarantee you they won't be. The client, if they're an emergency manager or the person accountable for resolving the crisis, is likely to have a much higher degree of risk tolerance because the stakes are very great and the problem is large. And so they'll do things they wouldn't usually do in order to solve an asymmetric problem. I think lawyers have to understand that mindset shift and understand when their risk tolerance has to change as well. The other thing goes back to that salty legal advice, and it's if you're going to articulate that there are a range of options, it's fine to provide the range. And in fact, it's great to provide a range, but you at least need to say what your advice is, right? So if you have 4 options, you say, there are 4 options, I rank them this way. Client might turn to you and say, what would you do? And I'd say, I do number 1. Here's why I do number 1. And Scott, the only other thing I'd add to that is, I think it's critical to teach law students and clients frameworks, right? We can teach analytic skills, but at the end of the day, there's just a couple critical frameworks. One comes out of the Harvard School of Public Health, which is swarm leadership. We can talk about later. One comes out of the work that Eric Stern's done around tasks of crisis leadership, because as a lawyer, you can help make sure that clients who are harried proceed through those tasks. And then the other is ethical framework, and not just the legal ethics, but the ethics of making decisions about people.
Yeah, thank you. And I know you worked with Eric, in your project doing simulations, which I thought was a brilliant way to, you don't have to learn this right in the field every time. You can actually design, and people like Eric are brilliant at doing it, simulations that lawyers get into and can practice and see some of these skills. Lisa, to pick up on something you said, interestingly, you're training lawyers in PR. Something tells me this has to do with adopting a broader perspective and exercising judgment. Say more.
Yeah, I'll jump to that, but I want to just build on something that was just said. I am also a big proponent, and we are a big proponent of teeing up options, but it's not just options, it's options with a discussion of the trade-offs. And I think that is super helpful because it does drive a more pointed conversation about the different risk trade-offs, which I absolutely agree with Brad. A lot of times lawyers and clients will start in a very different place, but that seems to be a helpful way to drive forward that conversation. The other thing I might add to that is, teaching lawyers it's okay to ask for advice and talk both to other lawyers. I mean, for us, we have a large department. We encourage people to reach out if they're struggling with issues, but even amongst a team, right? So you don't have to necessarily come with the answer, though I absolutely agree with what Brad said. A lawyer should have an opinion and why, but you can put forth the options, the trade-offs, have a good dialogue, and then collectively decide. Like, I think that's super helpful because it also then brings up maybe other nuances, because when the lawyer was formulating the options, again, back to something Brad said, if we don't fully understand the business and the objectives, we may be off on our options. And then I'll shift to just your PR point. And yes, look, a narrative and understanding your stakeholders in the broadest sense, super, super, super important. And PR always has a seat at the table for us very directly. And we actually have a PR team within our corporate, external, and legal affairs department. I mean, it is they sit with us. But what it does, I think, do probably more than anything else, as I think about the multidisciplinary nature and the multitude of stakeholders you can have, they are very good at bringing the perspective of helping us think through all the stakeholders and who do we need to think about, what is, they're going to be their concern, how are we addressing that with the path that we're going forth with. Are we addressing it partially or not? If we aren't, what are their concerns and how do we best answer them? But it's, that's not a skill set I certainly ever sort of came into a legal department with, right? But, getting some basic training and just understanding how that works is very valuable. And then, in some of the book, I know people talked about lawyers also having to engage with the press sometimes, right? And so just even having those kinds of PR skills are also helpful.
Thank you. Really interesting themes there that to pick up on. One of the things that I talked about in my chapter was we're teaching about design thinking. I'm running a course on design thinking for lawyers, and there's a couple of techniques we're deliberately trying to build into that. One is the stakeholder analysis. When you're trying to solve a problem, it's lawyers, we typically, lawyer psychologists, that we're autonomous. We're going to go off on our own and solve the problem. I know what your problem is. We don't listen very well sometimes. And, we want to prove that we're the smartest person in the room, maybe because it's back to first year of law school when the performance pressure to prove you're the smartest person in the room really comes to the fore. That broader stakeholder analysis and stepping back and asking questions and empathizing and understanding the problem from many perspectives and different stakeholders has been really helpful to our students. A second thing we're doing on this, on the thought of, teeing up options. Traditional legal education, of course, when you throw up an idea, you're supposed to gun it down from every possible angle as quickly, as brutally as possible. Our business school students comment in joint courses where there's MBAs and law students together that how come the law students are so mean to us in class, which is kind of funny. But what we're trying to teach separately, in the design process, the way designers work is everybody heads down comes up with a set of ideas individually, and then each individual gets up and presents their ideas without critique and shooting down the ideas yet. The group sits back after everyone has talked about their ideas, and then they can start to group. Then they can apply that rigorous analytical critical thinking. It's a much better and different process, and it's not that difficult to do. The last thing you said that I think is brilliant is it's okay to ask for advice. I keep telling my students about this because again, there's so much performance pressure, and there's this, idea that the lawyers got to on their own have the idea, and we don't teach lawyers enough to build networks, to ask for advice. Muneer, I think your example of how you succeeded brilliantly in the work you were doing in the immigration ban was that you had a network and you were out there asking people advice. Can you build upon that and what else you're doing in the clinic to foster, brainstorming, judgment, options, and network building?
Yeah, and I think this builds off of what Lisa was saying about the importance of teams, and to your point, Scott, about the kind of classical atomized approach to or experience of law school in the traditional classroom, which in many ways I think clinics are designed to try to counteract. They're a form of counter programming to that. And I've been doing clinical teaching for roughly 20 years. And I have, over that time, one of the biggest developments in my own thinking and understanding actually has been to center on collaboration, not as some kind of soft skill that is nice to have, but as indispensable to doing complex lawyering. And part of that is because no one of us can be expert on everything that's involved, particularly if we are interested in taking interdisciplinary approaches to problems. But even within the sole discipline of law, no one of us is going to bring the entire knowledge base that's necessary for the kinds of complex problem solving that we're talking about. But the other piece of this is that I think is very hard to teach. Your basic question, how to teach judgment, is very hard to teach judgment to individuals in an atomized environment. Judgment is not a reflex, right? It's not like either your knee bounces in the right direction or it doesn't. It's a process built through discernment and reflection. And each person on a team will bring their own contributions to that. But once we move beyond the simpler problems, the routine, repetitious problems, which are essentially, require a kind of algorithmic thinking, and we move into a space where the algorithm fails, where we have to build from the ground up what the options are, how to weigh the competing considerations, and to discern, the differences in positionality that Brad was alluding to. Those are things I think that we shouldn't trust individuals to do competently on their own. And so the team then is, again, not kind of a nicety in lawyering, but absolutely indispensable to it. And so what that's led to in my thinking and the work that we've done in our clinic is we teach about collaboration more and more and more. It started off as a topic that we raised periodically. It moved into it being a one-off class that we would teach, to it now being something we're teaching pervasively. And one of the measures of success for our students is have they come out at the other end of the experience with not soft skills of collaboration, but hard skills of collaboration. Can they point to the things that they do that have made them better collaborators, that are producing better results? And one last thing I'll say about this, we talk about a little bit, Mike and I, in our chapter, going back to kind of what the learnings of crisis lawyering have been for us. So we describe crisis lawyering as a kind of stress test of the organization, in this case, our clinic. So how well are certain infrastructural aspects of our organization holding up? And one of the things that we discovered in the context of our work on the Muslim ban, which relates very much this topic of collaboration, is that when the immediate crisis passed, when we had some time to do the kind of postmortem that Lisa was talking about, the reflection about what worked and what didn't work, one of the things that became apparent is that the distribution of labor in the moment of crisis was skewed. And in fact, it tracked onto the kinds of inequalities that exist in society generally. Different there, and not to put too fine a point on it, but there were kinds of work that we would think of as being kind of the unglamorous aspects of lawyering that fell disproportionately on women and students of color. And so that was a stress test for us. How good were our systems for ensuring the equitable distribution of work and opportunity in our clinic? And that experience showed us that there was a lot of room for improvement. So we actually, in the aftermath of that, made that explicitly part of our teaching and explicitly something that we were trying to measure. How are we doing on this score? And that changed the way we taught about collaboration. That made for us one of our teaching goals for students, for them to acquire the tools of awareness for how work is being distributed, and to affirmatively self-audit the roles that everyone on the team was playing, rather than waiting for the faculty to kind of raise that as an issue. For them to kind of set up their own teams, one of the things that we've tried to teach is what the infrastructure is for equitable distribution of work and opportunity.
Fantastic. You'd be interested to know that in my design thinking seminar this semester, my students all have client teams. One of the teams has a client that is one of our clinics, and the challenge they're looking at is workload management and distribution. So I might put them in touch with you. Lisa, when I talk to, I do a lot of teaching with, law firms. It's the primary place where you source your talent, and there's often, challenging transitions moving from, the private practice of law at a law firm to in-house practice. Especially around this notion of working in teams. When I talk to law firms about, have you done the postmortem? Well, we can't bill that to anybody, and there's resistance internally to put in any kind of structure around that. What would be, your take on how to better prepare lawyers for roles like yours, across the arc of their careers?
I think part of that is happening from what clients are asking for. And let me just give you an example from my perspective. If somebody gave me kind of the legal memo, and I will say I see them rarely now, but earlier in my career, we used to get a lot of the 20-page, let me give you the law memo. And we sit there and then I look at it and we're like, I have to make a decision. What is this thing telling me to do? It's giving me kind of all of that analysis, but no practical, what am I supposed to do? What is my path forward? I understand there's a lot of gray. I will say we will push back on our law firms, right? And we'll say that's not the kind of lawyering we need. We need people to kind of shift. And to the credit of the law firms, I will say people are doing that, because there's also, billing pressures as well. We all have budget pressures. So I do think part of it is on us as consumers of the legal services to provide the guidance on what is the kind of legal work product we need. So I think that is a helpful feed into the process of some change on that. The other thing I will say is, we have our outside lawyers very much as well as part of our teams. And hopefully that also then gives them some insight into in-house lawyering, because I do agree with you. I think it's different. At least for me, it was very different coming from a law firm to in-house lawyering. And one of the biggest changes was I was supposed to have an opinion, right? I couldn't just say, here it is, you decide. But I think when we work hand in hand with them and we do bring them in as part of our team, that is a helpful thing as well. But I would also then encourage like law firms to think about some of these different kinds of trainings. In some ways, if I think about law firms trying to design their practices and help their lawyers best serve their clients, if that's what clients are asking for, I do think there may be a growing sort of push within law firms to also think about how to provide that type of training.
Yeah, thank you so much. I'm going to invite Eric to join us and turn his camera back on for some reflections. Specifically, Eric, I know you and Brad worked really, really closely together on the FEMA project, brilliantly. A question I still had was going to try to ask Brad is, how do you prepare leaders to work better with their lawyers? And you guys did a lot of that. So that's just a prompt. You don't have to take it, but I'd love to wrap us up for the next 5 minutes or so. I'm
not sure how far I'm going to get on that one, although it's definitely going to be implied in what I want to say. So it seems to me, if we think about the task of preparing lawyers to participate in crisis management in the environments that we're seeing now and that are likely to become more challenging in a number of ways moving forward, there really are two pieces that we've been hearing about. So one is the question of defining the lawyer's role or roles and having the lawyer perform excellently within their professional specialty in playing the role of the lawyer. That's actually more complex than it sounds. And in the first panel and in this panel, we heard about the role of lawyer as narrow technical expert, and we heard the role of lawyer as wise counselor and connector and conflict resolution specialist. And so that's a lot, just that. Then there's the second piece, which is preparing lawyers to work with other people, including leaders, and vice versa, preparing other people to work with lawyers. And I do have some thoughts about that. One of the best ways to do this is to practice in safe circumstances. And so the simulations that you alluded to before, role-playing exercises, give people a chance to practice their professional skills, even to inhabit other roles. And this is really critical. If you want a lawyer to work well with the public affairs folks, the communicators, as Lisa was suggesting, a very good way to do that is to let the lawyers walk a mile in their shoes, and to give them an opportunity to answer a journalist's questions and see what the headlines might be, what story the lawyer would write, and show them the consequences of saying no comment when there is a situation where the brand of the company is at stake, where there's a perception that the company is not taking responsibility. And so that the lawyer really understands how difficult the job of the other professionals are. Maybe even more importantly, giving the lawyer a chance to inhabit the role of the decision maker who has to make these tough calls where perhaps rules or administrative constraints seem to be at odds with the humanitarian imperatives of helping people in dire distress. And so to have to give the lawyer a sense of why it is that, as Brad Kieserman said, the leaders need solution-oriented advice that will advance the overall mission. And remembering the mission, and in the realm of where FEMA and the Red Cross work, this is about helping people who have had their lives and livelihoods disrupted by disaster. And so empathy for the other role players on the team, and empathy for the disaster survivors and others in that ecosystem, really, really vital. And in fact, one of the results of Brad's survey early on was that the lawyers lacked all of those kinds of empathy. And so we designed exercises for the lawyers to try to build empathy and give them that bigger picture and a better capacity to understand the others and what is at stake. I really like the point that a number have made about ethics. And this is particularly important when it comes to government lawyers. For government lawyers, they get a ton of ethics training. And most of that training is all about who you can accept a lunch from, or what types of gifts you can get. And it's in a very narrow anti-corruption type of context. But the realm of crisis management, disaster management, emergency management, spaces that we are talking about here, there are big questions of right and wrong, questions of value, and how to weigh competing considerations against each other. This is the realm of the moral philosopher. That might seem abstract, but thinking explicitly about some of the yardsticks we use to determine right from wrong and to help those who have the responsibility to make choices to better see right from wrong and make the right choice. That, in fact, when we interviewed the FEMA leaders, the federal coordinating officers, senior leadership, we asked them what they wanted in these crisis situations. Many of them said, we want to do the right thing. Well, that's great, but the hard part is figuring out what the right thing is. And I think thinking more systematically, seriously, deeply about ethics and preparing lawyers and those they work with to think about those bigger ethical questions is really important. And that is, I think, one of the ways that you teach judgment. And I will leave it right there.
Thank you, Eric. This interdisciplinary approach and bringing your expertise in crisis leadership to the legal profession is truly groundbreaking, and we're really grateful for the book, for you and Ray. I want to say thank you so much, Muneer, Lisa, Brad. This has been the most fun I've had in the panel for a very long time, and I'm really grateful for all the great ideas you've given